Welcome to our continuing YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be discussing the concept of the release. So the release that we're talking about is when an employee has been terminated, fired, relieved of their job, dismissed from their employment, their employer says, here you go, we're going to pay you potentially severance in addition to your termination pay, and we're going to have you sign off on a release agreement, which upon payment specifies that you aren't going to be able to come after myself, the employer, again, because we've paid you this money and you've relinquished all claims to come after the employer. So, given the financial straits that most people are, especially when they lose their job and they don't have any assurance that they're going to have employment, and they're presented with the opportunity to have $20,000, $30,000, oftentimes people will sign those releases because they feel obligated to. And then they go and they talk to if they're given time, and we're going to look at one case where being Rubin versus Home Depot, Canada, where the individual signed on the spot. But even if you're given time, you go and start talking to a lawyer, and the lawyer starts talking to you about the costs involved, the implications of not signing it, which is appropriate. People get reluctant oftentimes to not sign the release and not take the money that's on the table because they're concerned, what am I going to do? Maybe I can find a job in the next month or 2 months and this will tide me over. But if I don't, what's going to happen? Am I going to lose all this money? Am I going to have to spend lots of money on lawyers? Something that seriously people do consider, and you should be considering. And that's why you need to be talking to various lawyers, in particular about the circumstances, because every lawyer is going to have a different approach. And there's and I say that because there's certain approaches that clearly are not being taken by certain lawyers with respect to the scenario before them. Because if they were taking that approach, a lot of the issues might not necessarily be there, but it's all heavily dependent on the facts and circumstances, how the lawyer perceives them, what the situation is, what the employment arrangement is, who the employer is, the background circumstances, a whole lot of aspects. But I'm going to pull back and focus more on the release itself. But one of the key things is that people get let go from their job and they have a need to obtain the money that's on the table. Even though they might well be entitled to more money, they're not prepared to take that more money because of the risks associated with it. And the question then becomes whether they can reduce those risks. But let's move back. So you've got a release in front of you, and it says you're signing off on all these rights, take the money, be done with it. There are arrangements, and with the right lawyer understanding the particulars of it. And I'm not saying there's bad lawyers out there, but there's lawyers that might not perceive angles, and that's why maybe you should talk to a couple lawyers before you commit to one direction or another. There might be ways, especially if you've signed the release, to break the release, to deal with the release. And this is but one of the ways that is possible to deal with a release that's been already signed and to proceed. Another common one that you'll find is with respect to human rights. That allows a different angle. And there are some other angles that we know of that we pursue that we don't discuss necessarily in this YouTube video, because we don't want to send people off on the wrong path. until we all have all the facts and circumstances before us, and because it's somewhat proprietary. But let's get into the scenario with Mr. Rubin. So Mr. Rubin was fired from Home Depot. And he came in and he found himself being let go and without any prior warning, terminated. Had to attend the meeting, provided with the paperwork for his termination, provided with a release. Now, what he was offered was the equivalent of 28 weeks pay in lieu of notice, which amounted to just 2 days more than what was otherwise provided in the Employment Standards Code. Now, Mr. Reuben signed off on the release, felt pressured. He was a vulnerable person. A lot of factors, once again, factors, critical thing to remember in the situation. And he needed the money. So he signed it off, took the money, came to the realization that he's undercut by his employer who got rid of him. So what does he do? He talks to a lawyer. The lawyer pursues this and says, "You've gone too far. This is unfair. It's improvident." Wasn't given the opportunity for independent legal advice or pseudo advice. There's the imbalance in power, his own ignorance of business, his illiteracy, lack of knowledge of the bargaining language, other disabilities and ailments. All these different things could come into play. Some of them in his situation, looking at the Court of Appeals in Kane versus Clerica versus Life Insurance, many of these different aspects can come into play. And when this emerges, right, we have issues. So what did employment standards say? Well, employment standards technically said he was entitled to 27 3/4 weeks. What was he offered? He was offered 28 weeks on the package. So just above the basic minimum. And that's a critical thing. And the court was not a fan of this. So the court went through the various aspects, starting off with asking the question, was the transaction grossly unfair and improvident? Just offering an extra 2 days before the Employment Standards Act? In this circumstance, definitely. The court didn't feel that was appropriate. Went through a lengthy analysis of it. Came back and said, that's not appropriate. Lack of independent legal advice. Always a major forerunner. Where employees need to know their legal rights. And this is set out where the court, in this case, drew the attention was to the Supreme Court of Canada in Matchinger versus HOGJ Industries Limited. The importance of the employee who's in the weaker position having the opportunity to get proper legal advice, especially before signing a release. Something that was not allowed. Very serious consideration in this case, in most cases. And that is why oftentimes employers say, take the package, review it, have the opportunity to review it with a lawyer, and then come back to us in a week whether or not you take it. That's what they try to rely upon. And oftentimes that's what their argument is going to be. And it can be plausible. But that is why you need to always be talking to a lawyer, even after you sign the release, to see if there is a way to deal with that. And that is the situation. So the next point they looked at, the overwhelming imbalance of bargaining power caused by the victim's ignorance of business, illiteracy, ignorance of the language of the bargain, blindness, deafness, illness, senility, or other disability. And here again, they're looking at the Court of Appeals, Lloyd Bank Limited versus Bundy, where Lord Denning, one of the great jurists, talked about the importance of dealing with this imbalance, inequity of bargaining powers that exists between parties and not allowing it to unfairly impact individuals. That doesn't mean that you're going to be able to say, in every circumstance, the employer is always more powerful. Everything I sign off in a release is always going to be thrown away. That's not the test, but that's not the question that we're looking at. What they're saying is they're looking at this in the whole scope of things and saying, has there been a severe abuse of this imbalance? And that is of consideration. Next, we'll look at the fourth element, which is the other party knowingly taking advantage of this vulnerability. So that meaning, did the employer, in this case Home Depot, knowingly take advantages of the vulnerabilities of Mr. Rubin, the employee, enforcing this upon him, making him sign off on him, and not providing him with a choice? And that is really where it comes down to. It's, again, fact-based. And in the court's determination, they went through all these various aspects, and they said, look, it was improvident what was done. It really shouldn't have been this way. And what did they come back? And they came back and they're saying, this was not reasonable. And they set aside the release. And they said, we got to then determine what is reasonable notice in the circumstances. And that's really what it came down to. And we're looking at Mr. Reuben's counsel talked about 20 months. Home Depot said 7 to 10 months. They looked at the guidance of the various things. And the court found somewhere in between. They said 12 months. And they said 12 months, salary, other benefits that he was owed. So what were we talking about initially? They tried to impose upon him 28 weeks. 28 weeks, which is less than 6 months that they tried to impose. And they signed off on. So at least he got doubled up. Trying to get at least, thought it was more appropriate. 4 times the amount, and got twice what he was entitled, what was there. So the thing is, the court didn't believe in the release. Circumstances dictated that. Remember, circumstances, and that's a critical thing. So what you need to do is, you've signed off on a release, and you're trying to figure out, what do I do? Well, you might be out of luck, but you might not be. You got to look at the stuff. You got to see what your lawyer thinks with respect to the angles. You got to look at the risks, the rewards. What is it going to be required to get away from the release? And what's it going to entail? Is there a legal basis to move forward? And if you find out and you feel like you have been aggrieved and you took something that's too little, circumstances were such, and you have to move away from it. There are circumstances, and I believe there are, in fact, more circumstances than people realize that could enable them to get out of a release. But what is that going to take? That is something for you to assess and to take guidance on and look at. Because it is never as clear cut as it might seem. And simply because you are presented with what seems to be a final solution, conclusive by the employer, here's the paperwork, you've signed everything away, it does not mean everything has been signed away, as was demonstrated in the case of Reuben versus Home Depot. And there are other circumstances which can enable you to break the release because the release was not appropriate. But the only way to determine that is to engage with legal counsel, go through all the facts and circumstances, be fully transparent and honest and get an honest and clear response back from the lawyer. And that should shape your determination as to how you proceed and move forward. Because that is how you make a determination appropriately, and either you move forward or you accept what you took. But it requires that you put in the time, you speak with the lawyer, you become fully engaged, transparent, clear, and you don't devolve and you don't avoid troublesome issues with respect to the situation. And don't try to create something that you can't sustain. But you look into it. Because the reality is that employers are not necessarily interested in giving all that is due to their employees. They're more than happy if you take a package, sign off on some papers, and walk away having only taken half or 3/4 of what you are due. Just like Mr. Reuben had walked away and took only half of what the court eventually assigned to him. That is the issue, and that is what you have to be addressing. Do not simply walk away too quickly from this stuff just because you signed a release. Consider it. Speak to legal counsel. Speak to more than one lawyer. If they say there's nothing we can do, don't take that as the end of the world. Take the opportunity, contact another lawyer, and see about what they believe to be the situation. And then proceed from there. Because the worst thing you can do by asking a second or third lawyer is have them tell you the same scenario. They've analyzed the law, the circumstances, the facts, the release agreement, and there's nothing to be done about it. And at least then you have the confidence, at least to put it behind you and say, look, I spoke to 3 different lawyers. Each of the lawyers said the same thing or said something similar, or 2 of them said the same thing. The other one said there's a possibility, but here's the risk, here's the cost. It's too much for me. But shouldn't you at least be asking? Because you might ask those 3 lawyers. 2 of them might tell you that story. Third one says, here is a strategy we have. Here is the risks. Here's how we minimize the risks. Here's the rewards. Here's how we avoid making this costly for yourself. That might be available to yourself, but you only find that out if you take the time to speak to more lawyers, to engage more people. And that is the reality that we live in. That is how you have to deal with these circumstances. Because there might be nothing there, but there might be something. So if there is something, why not inquire? Well, I hope you found this YouTube video informative, provided you with some insights, and let you know that there are possibilities with respect to signed release agreements to moving forward and dealing what might be entitled to yourself. So I hope you found that interesting, and we look forward to speaking to you again. Thank you.